So, no, I wouldn't say I have a passion for HR.
Welcome back to Human Resources for the People. It's a human capital revolution. Today we're going to be taking a look at recommendations General Counsel Abruzzo has made. She's the General Counsel of the National Labor Relations Board, and she wants the National Labor Relations Board to take a look at a few decisions that were too employer friendly. I presume made during the Trump administration, if I had to assume, but I don't know. This article is from John Hodges Howell and Peter Finch, and it's out of the employment law firm of Davis, Wright, and Tremaine. So on March 20th, General Counsel Abruzzo released a memorandum, GC 2304, and she does this pretty frequently. She had one on August 12th of 2021, and it's a mandatory submission to advice. And basically what these are is she feels that things need to change. There were decisions made by the National Labor Relations Board, presumably under previous presidents, but it could not have been, but for the most part, under previous presidents. And as a result, she wants to look at them again with a new lens. You know, from an HR perspective, these get very frustrating because we have a constant change with respect to the rules that we have to follow. It's just a never-ending sort of carousel of what actually is the rules surrounding human resources and employee relations. She made a lot of recommendations, and they're listed below. I'm not going to go over every single one of them, but you can take a look and kind of see there it's a little bit coded, it's a little bit difficult, but the one that I think is most interesting is that she wants the board to review what's inherently protected concerted activities. Now, to sort of go back to what inherently protected concerted activities are activities in which employees get together to either attempt to unionize or otherwise do collective action. And concerted activities right now, even now prior to the National Labor Relations Board, can be very broad. In fact, some National Labor Relations Boards under various presidents have defined concerted activities as swearing at a supervisor or calling them an idiot or in front of other employees. The most clear one, the one that people are most familiar with, I think, is discussing pay. That's considered a concerted activity under Section 7 of the National Labor Relations Act. And as a result, it's prohibited to prohibit employees from discussing their pay. So she wants to expand it to look at rate. The next one up that I wanted to cover today was the expansion of Weingarten rights. So there was a case a little bit a while back, I presume under the Trump administration. Sorry, let me start off with what Weingarten rights are. Weingarten rights are in a union shop, you have the right to have another person present, another union member present when you're being questioned on something that may lead to discipline, including termination, right? So you have the right, under the Weingarten rules, you have the right to do that, and that's a long respected rule. I believe it goes back to the 60s, but you have that. Now, the National Labor Relations Board has switched back and forth with whether or not Weingarten applies to non-union shops. I believe right now it doesn't, but it has in the past. Regardless, as an HR practitioner, one of the best recommendations is just to allow people to have another witness if they'd like in an investigation, because it doesn't really matter. But regardless, there was a case a while back. The employee wanted access to this one seems like a no-brainer, but she says that electronic surveillance or algorithmic management that might interfere with Section 7 rights should be maintained confidential. understood that. I think that that's probably, I wouldn't be surprised if that includes spying or spying on employees. So I understand the idea. I just thought it was interesting. And it was interesting that that was something that was being pursued by Abruzzo, the idea that this sort of electronic surveillance might interfere with concerted activity with Section 7. And then Abruzzo finishes it, which I particularly, I respect this potential. I think that some of the things that she, presumes to that presumes that impacts workers' rights really don't. I mean, I really I don't think that, but she has made this argument here, and she said that because she's putting it in front of them, she's board law. Without doing so, board law undermines workers' statutory rights, remain unchallenged, which will continue to detrimentally impact millions of employees throughout the country. And I agree with that. The way she's tackling it, I don't know, but I agree with the sentiment at least. What do you think about today's video? Please comment down below, like, share, and subscribe. It really helps out. And I'll see you on the next one. Bye, guys.